enterprise or the organization that the state is alleging that he's, or has shown that he's a part of, which is the Jackson County Sheriff's Office, between taking the evidence in the light most favorable to the state, that there's no meeting of the minds, there's no common purpose between what they're alleging Zach Wester did and what the purpose of the organization that he's a part of. In this case, there was, in this case actually did involve one police officer. And this Gross v. State, what they were doing, there was one police officer, he recruited some other people, ended up being a small group that were dressing up as police officers and going in and robbing people. The defendant, in this case, Gross, wasn't going into the houses, but he was helping plan the robberies and scoping them out. And they found that the enterprise was the group of people committing the crimes, not the police. And the court said there, evidence supported finding that the defendant and his associates shared the requisite common purpose of an ongoing organization necessary to support the finding of an enterprise under the Racketeering, Influenced, and Corrupt Organization statute. Even the statute says corrupt organization. So this group, while there may have been one police officer involved in the group was the core group with the common purpose of committing those crimes. We don't have a common purpose.
What statute are you referring to, sir?
I'm referring to Gross v. State, which is a Florida Supreme Court state, which is...
Put that cite in the record if you don't mind.
What was that?
Put the cite in the record if you don't mind.
I did earlier, but I'll give it again, Judge. It's 765 Southern 2nd 39.
Okay.
And that was, I was specifically looking at Head Note 5 on that, which talks about the requisite common purpose of an ongoing organization. The second case that the defense had submitted last week was Jackson v. State, which is out of the 3rd District Court of Appeal here in Florida, 858 Southern 2nd, 1211, or yeah. In this case, the defendant had been charged with RICO with underlying offenses of cocaine sales. The allegation where he was selling cocaine in a park where other gang members were also selling cocaine. They charged him with RICO, but there was no evidence to show that he was a part of that group. Therefore, he couldn't be convicted of being, gang adjacent. There was no showing that he was a part of that organization or any other organization. The state then submitted some case law last week, 3 cases specifically dealing with the enterprise issue. The first case that they submitted was United States v. Welch, which was 656 Federal 2nd, 1039, a 5th Circuit case. And I guess the point of the case there that they're trying to show is that, hey, now here we have a sheriff's office that is the enterprise. Well, in that case, the sheriff and other deputies were actually providing security and looking out for a gambling ring. So therefore, there is that common purpose of the group there within the sheriff's office, which is still different because there's still no showing of a common purpose between Mr. Wester and the Jackson County Sheriff's Office. The next case that they cited was State v. Jackson. And this is one where they're saying, okay, well, now you have one person committing the crimes that's part of an organization. But in this case, we're talking about a law firm and some other companies that was created by the one person who was committing the crimes. So it's still distinguishable because we have now a guy who has created these businesses, created these organizations for the specific purpose of committing these crimes. So therefore, I think it flows. You can show there's that continuity, there's that meeting of the minds between the individual and the business. And then the third case that they cited was State v. Doorball v. State, which is 983 Southern 2nd 464, which is also a Florida Supreme Court case. And in this case, the state had tabbed for us and highlighted that to prove the element of enterprise, the state must prove, one, an ongoing organization, formal or informal, with a common purpose of engaging in a course of conduct, which two functions as a continuing unit. But if you read just the next couple of lines, it says to satisfy the enterprise element of the RICO statute, the state must demonstrate that a defendant acted in concert with at least one other person, organization, or entity. There's been no showing that Mr. Wester acted in concert with anybody. According to their allegations, you have the Jackson County Sheriff's Office, Mr. Wester, who was employed by the Jackson County Sheriff's Office, but what he was doing was in contradiction to anything that their purpose has been stated. There's been no showing that the Jackson County Sheriff's Office is corrupt. Only their allegations are that Mr. Wester was corrupt. And there's no showing that they were working in concert together towards that common purpose, that common goal that we heard about earlier from the other cases. Judge, I submitted two other cases to you over the weekend. The first one I'm going to address is Nazar v. City of St. Petersburg. This was actually an opinion from the Middle District of Florida, but as we know, our Florida RICO statute was modeled after the federal statute, and we know that the Florida courts look to the federal interpretations. This case was a civil suit filed under the RICO statute. The quick facts are there was a gentleman at a bar in St. Petersburg who was basically beat up by a couple of bouncers. He filed a civil suit against them, one of them being RICO. And in dismissing that RICO count, the court said, the facts alleged in the amended complaint plainly do not state the existence of a RICO enterprise or a pattern of racketeering. There are no allegations that $5, and $5 was the bar that employed the bouncer, exists for the purpose of conducting illegal activity. And again, that's what we don't have here. We don't have anything showing that the Jackson County Sheriff's Office has anything to do with what the allegations are. I think what the state needs to show is some type of meeting of the minds with that. And then the other case that I submitted yesterday, Flanagan v. State, which is 566 Southern 2nd, 868. The court there says, due to enhanced sentences involved in racketeering, influenced, and corrupt organizations, it is essential that definitions used in RICO statutes be strictly construed in order to ensure that criminal organizations, which are RICO's target, are distinguished from individuals who merely associate for commission of crime. The court in Flanagan goes on to state that an enterprise is characterized by three elements: a structured organization that exists separately from the pattern of racketeering activity, continuity of structure and personnel, and a showing of a shared purpose. All three prongs must be present to establish an enterprise. Again, we have no showing of any shared purpose. And then the state submitted three more cases over the weekend. The first is United States v. Blackwood. And again, I think this would similar to the sheriff's office, or not even that similar, but in this case, yes, there was a police officer that was involved and charged with RICO and convicted, and it was upheld, but it was not the organization, the police department that he was working for. Where the crimes were taking place was in the traffic court. And that's what the court specifically said was the traffic court group, where they were bribing people and getting rid of tickets. He was a part of that group. And it wasn't just because he was a police officer, and it wasn't the police department that he worked for. That was the enterprise.
What was the enterprise?
The enterprise was the traffic court, the loosely associated people in the traffic court that were bribing each other, paying off judges to get rid of traffic tickets and things like that.
So it was more than one in that case, is what you're saying? More than
More than
was
one person?
Part of the improper activity or illegal activity.
Yeah, I mean, that court says, and even the state says that, you know, in their little one-liner that they gave us on it, that a police sergeant with the county traffic court, where the traffic court was listed as the enterprise. So it was the traffic court, not the police department.
But I guess the key distinction for the court's purposes is there was multiple actors. I mean, that's really the
Right.
basis of your
There were
argument.
multiple actors. In every one of these, there's been multiple actors, except for that the case that I mentioned earlier with where the RICO was overturned, where the guy was out selling cocaine by gangs, but there was no evidence to show that he was a part of the gang. So therefore, the appellate court dismissed the RICO charge. The next case.
That's been the challenge for the state, and that's been the discussion all along, is to show me the isolated one-party acting solo rogue in an otherwise uncorrupt organization.
Right.
That's been the challenge. So I hope the state's ready to meet that burden.
And let me just, if I could, I just have a couple more.
No, you go through it. I'm sorry to interrupt you.
Okay. The next case they submitted was United States v. Pressgraves, which is 658 Federal Sub 2nd 770, which is a Western District of Virginia case from 2009. Now, in this case, they do have a sheriff who was convicted of RICO, and they did say, and the court found that it was the sheriff's office that was the enterprise. I would liken this case back to the lawyer who created the organizations to commit his crimes. Here we have the elected sheriff who is at the top of the food chain in that office, who is the one. So I think that's how that is distinguished from what Mr. Wester, what the allegations are against Mr. Wester. Mr. Wester was not in charge of the Jackson County Sheriff's Office, and in this case, because it was the sheriff, I think the court could easily say that the sheriff's office was corrupt. Because I think if we move forward on the RICO charge, the court is going to be saying that the corrupt organization that he was a part of was the Jackson County Sheriff's Office. And there's been no evidence to show that the Jackson County Sheriff's Office was corrupt. The allegations are against individually Mr. Wester. So I think that's how we distinguish this from Pressgraves. And then finally, we have United States v. Pledge, which is listed as 51 Fed Appendix 911. Again, this is a police officer who was charged with RICO, but there was nothing in the opinion stating that the police department that he worked for was the organization. But there were, when you read the opinion, you will see that there are other people that he is working with, where he is actually trafficking in drugs. He recruited somebody else to move drugs. So there's that enterprise, is his people that he's committing the crimes with, not the police department that he's a party of. So Judge, based on a review of all the case law, I don't think the state has proven that there is enough to move forward on the RICO charge, especially because they cannot prove an enterprise that Mr. Wester was working with, cooperating with, and had a common goal or scheme. Thank you.
All right, State.
Judge, understanding the court's questions and concerns of the issues that you raised to us last week, I've searched for specifically a state of Florida case on this issue, specifically a law enforcement entity listed as an enterprise for a RICO case with a sole actor defendant as a member of that enterprise. I have not been able to find where that issue was addressed by an appellate court in the state of Florida. If I had, clearly I wouldn't have provided it.
Have you found one anywhere in federal court?
I have, I believe that I've provided, the three that I have provided in federal court
In which of those cases, other than the sheriff's case, was the actor acting in a solo capacity without any assistance from anybody?
One moment, Judge, I'm just reviewing the Presgraves case.
And let me I'm going to just read that Nazar, just a sentence from that Nazar case for you, and I want the state to tell me how this fits under this sentence. The Florida RICO Act is informed by the federal RICO statute, and courts often look to the federal statute in interpreting it. To state a Florida RICO claim, the plaintiff must show the existence of a RICO enterprise as well as a pattern of racketeering activity. A RICO enterprise is a group of persons or associates that exist with the purpose of conducting illegal activity. Who are the group of persons or associates, both plural, in this case, which exist with the purpose of conducting illegal activity?
Judge, our response would be that the defendant's coupling himself with an enterprise.
What case says that a RICO, this is what this case says, a RICO enterprise is I agree that the sheriff's office could potentially be an enterprise. I guess under RICO, is there a requirement that there be some concert with some, whether it's a third party outside the sheriff's office could potentially be an enterprise. That's the cop who gets with the drug dealers and they start selling drugs. That's that case. That is the enterprise. Or multiple cops under the sheriff's office or police department's office that are working for the purpose of conducting illegal activity together. I guess I'm struggling. The only case that I can see that really fits that mold that you've provided, in my opinion, is the one with the sheriff that it really doesn't discuss it much, but it indicates whatever he was doing was in a solo capacity. I do think the other two cases indicate that there were multiple actors in some improper scheme. The clerk's case indicates that. Wouldn't you agree that there were multiple, not the clerk's case, the traffic court case indicates, would you agree that there were multiple people acting improperly in that traffic court scheme?
Yes, sir, and I agree with that. The only factual distinguish that I would make at this point is that the listed defendant, the charged individual, was clearly a person. But yes, sir, I agree.
Say that again.
The defendant in that case was a single sole defendant with a charged enterprise. But I agree that there were...
Sure, but he was working in... I guess explain the distinguishment to me. Why is that critical to this court that the named defendant was part of a larger scheme? Why is that a critical distinction in this case?
Well, in response to a previous question by the court had asked me, the state, in the context of plural, and I answer that, and the coupling that we have in this case, this Wester case, is that the defendant coupled himself with an enterprise. So it was merely...
But does the enterprise... Okay. But the deeper question is, does the enterprise have to have a purpose? And I'm going to read this sentence again.
Yes, sir.
A RICO enterprise is, so it equals, a RICO enterprise equals a group of persons or associates that exist with the purpose of conducting illegal activity. That's the quote from the case.
Yes, sir. Our position...
And that's a 2017 case.
Yes, sir, and I don't dispute that. Our position in this case, the facts of this case, State of Florida versus Mr. Wester, demonstrate that, yes, the defendant acted alone. I'm not trying to claim that any other witness in this case acted in concert with him for a criminal purpose.
Okay.
Okay, so I absolutely am not trying to claim that. However, his actions under the color and the use of that enterprise were continuous. They demonstrated a pattern of illegal conduct. In other words, he's using this enterprise for that purpose in a common scheme. I believe evidence has been presented that a trier of fact.
I agree.
Okay.
Everything that you say is true. I mean, that's the issue is, can somebody acting in a solo capacity versus a group of persons or associates, both plural, that it exists for the purpose of improper activity? That's what the case law says.
I would say, Judge, that, and I am not saying clearly that the Jackson County Sheriff's Office during this charge timeframe only existed so that the defendant commit crimes. Clearly, I'm not saying that. However, I think the other cases that the state has, these federal cases and.
Which one? Give me your strongest case right now. Let's go through it. What are you hanging your hat on here, case law wise?
The county sheriff, the United States versus.
I would agree that's probably your best case right now. Let me pull it.
Yes, sir.
That's Pressgraves. That is a Western District of Virginia case. 658 Federal Supplement 2nd 770 is what I think it is. It's a 2009 case. The case that I've been discussing, which is the case that was provided and talked about earlier, I think is a 2017 Florida case. But go through the Pressgraves case with me and tell me what you think it shows and how it's applicable in this case.
I'm just making sure that I'm at the right page here, Judge. If I could just have a moment. Judge, on printed page 6,
Okay.
in the last paragraph, I believe in this portion of the opinion, they're specifically addressing and examining the nexus between that sheriff's office and the alleged racketeering conduct. And just for rec purposes, this is the case where it's a sheriff acting alone and in his capacity. Now, Mr. Wester was not a sheriff. He does not enjoy the same authority over the organization that clearly this case would have had. But Judge, I would submit that though this is a sheriff and it is factually distinguishable, that there is not a heightened standard for someone's use of an enterprise if it is a law enforcement entity. I believe that the plain reading of the enterprise element and its definition does not require a heightened standard or additional facts when it is a law enforcement entity. I know this is not the criminal case, but clearly what we're relying, this was not a law enforcement entity case, but the Jackson case that I initially cited in the first JOA paperwork, and that's the law firm, that is different. I freely agree with that. But I believe that same logic applies and that there is nothing in the statute or the case law that I've seen that requires a heightened standard when it is a law enforcement agency versus a law firm that otherwise can practice law and functions.
I don't think there's a heightened standard.
Okay.
I don't buy that argument.
Okay.
I don't think that there's any heightened standard. I think that the standard's the same.
And I didn't mean to imply the court does.
No, but I want to put that out there because if that's an argument, that's not even, I don't think that there's any heightened standard because I think that the statute and the case law is clear that an enterprise can be a sheriff's office as it can be a group of drug dealers under qualifying circumstances. So I'm not concerned with the sheriff's office being an enterprise.
Understood, Judge. And factually, just as Mr. Davis has, the state has done the best they can to try and find a case directly on point. And the facts in this case, clearly, and I'm not trying to say otherwise, are that Mr. Wester acted alone, but that he could not have committed these acts without the use of the Jackson County Sheriff's Office. That's all, Judge.
Fair enough. All right, Mr. Davis, any final word?
Yes, sir. Judge, I just wanted to, again, reiterate, with the Presgraves case, that was the elected sheriff. That was his office, and I believe by him being convicted, that was showing that that office was corrupt. I just wanted to point out again, in the Flanagan case that I provided over the weekend, which was the 566 Southern 2nd 868, in this case what happened was there was a police department sting where they set up a shop where people could come in and fence goods, sell stolen goods, and they charged Flanagan with RICO, saying that he associated with the sting operation, associated with the police to commit his crimes. And the court said that, and their opinion says, the state argues that by participating with law enforcement, the defendant associated himself with a structured organization which operated in the same manner and with the same personnel. Under the facts of this case, the defendant was not an enterprise, nor could we say that he worked through a business enterprise. Therefore, to accept the state's argument, we'd have to hold that the sting operation itself was a criminal enterprise. They would have to hold that the police department was the criminal enterprise. So I think the theme through all of these cases, when you're looking at the enterprise, has to be corrupt. There has to be a showing of a corrupt enterprise. So if we're going to move forward on the RICO, we're saying then that the Jackson County Sheriff's Office is a corrupt enterprise.
Okay. All
That's
right,
it.
thank you, Mr. Davis. All right, anybody want to say anything else with respect to the judgment of acquittal motions?
Judge, may I briefly confer with co-counsel?
Sure, go ahead.
No, Judge.
Okay. All right. I'm going to go ahead and make an oral announcement. I'm going to go ahead and deny the motion for judgment of acquittal. I will continue to monitor specifically count one. I would note that the defense has set forth a continued and overall judgment of acquittal renewal, so it's not necessarily limited to count one, as Mr. Davis's original judgment of acquittal motion was pertaining to all counts, as if I remember that, Mr. Davis, correctly. So the renewed motion has been thought through as far as the racketeering, but also the remaining counts. The court is still, I'm telling you, this is a tough issue with the racketeering. I think that there's some positive case law going in both sides' favor with respect to the arguments being presented. At this point in time, I am going to let it go to the jury, and we can discuss it later as needed and brought up. I'm going to pivot at this point and go to...
Judge, if I could,
Yep.
Are you saying you may change your mind on your ruling? Or?
Nope.
Okay.
No.
I didn't know if I needed to be prepared to make some more arguments later.
No, it's going to the jury as set forth the count one racketeering, and we'll move forward in that direction. As far as where we're at in this trial right now, Mr. Davis. All right. Let's go to our jury instructions. Everybody will pull those out.
Your Honor, does the court have, I know we had emailed copies to the court. I printed off an additional hard copy.
Bring me the most recent just to make sure. Yeah, okay.
Yes, sir.
All right. I'll make sure this is what I've edited.
The judge, Mrs. Nowak, my co-counsel, is going to make any required live edits here in
Okay.
the courtroom, if that's all right.
All right. First thing that needs to be done, and just this is a court preference, this isn't a mistake. I'd like the case number to be put in the pleading form. So that would be 19 CR 431. Second thing I want to discuss would be on page, so I'll just go through. 3.1 is the introduction to final instructions. 3.2 is the statement of the charge. The next one is count 1, racketeering. It's the bottom half of page 1 and all of page 2 as set forth. And then the top of page 3 is the racketeering charge. The next reading will be under 2.2-13, official misconduct. The Supreme Court instructions that the court has indicates that official misconduct constitutes 2 elements. I see that we broke that up into 3 elements. Why did we do that? Why do we sub-break it? Official misconduct under 19.7, it says to prove the crime of official misconduct, the state must prove the following 2 elements beyond a reasonable doubt. So why do we break it up into 3 if there's 2? Yeah, thank you. And I'm looking specifically at Supreme Court instruction 19.7. They're not necessary, let me say this, what you did is not necessarily wrong. I'm just a judge if there's not a reason to change the Supreme Court form, why are we doing it?
I agree, Mrs. It's my responsibility. I'm lead counsel in this case, but I relied on my co-counsel to help prepare this, so she's just pulling that up. While she's doing that.
Again, it's 19.7, official misconduct. It's at the very top of the page.
Was there any additional language that was added, or did she break out a third element, number 3 there, where there is no number 3 in the official instruction?
Let me look again. She basically rearranged it without adding anything. I don't think there was anything added substantively. The language is, the reading is different, but there's nothing substantive different, I don't think.
Okay, I agree with the court. That's the proper way to handle it. What we'll do is we'll make sure this is cut and pasted, and that there's no additional, nothing labeled number 3, and we're going to fix it where it says following 2 elements.
Okay.
Following 3. Yes, sir.
All right, the next thing is, number 1 says Zachary Wester is a public servant or public contractor.
Yes, sir.
Is there any debate that he's a public servant? I don't know how public contractor applies in this case. Anybody want public contractor in there? He's not a contractor, he's a public servant.
Yes, sir.
So let's take that out. Also, if you'll go back to page 2, at the top of page 2, it says, for official misconduct, the state must prove the following elements. Zachary Wester, the public servant or public contractor. I'm going to go ahead and take public contractor out of that as well, because I don't even want to get into the contractor stuff. He's not a public contractor, he's a public servant. And I'm going to take out on the next page, which I believe is page 4, the public contractor definition, because that's not applicable. Page 5 is counts for perjury and counts for fabricating evidence. The next page is counts for possession of a controlled substance. The next page is counts 38 through 48, possession of a controlled substance. The next one is count 49, possession of a controlled substance. The next page is counts 50 through 60, possession of drug paraphernalia. Insert at the third to last paragraph, last sentence, control can be established by proof that, don't take out the parentheses of defendant, that should be his name there.
Yes, sir.
The next page is a continuation of the reading for 50 to 60. The next page is count 61, false imprisonment. It also includes count 62 on the same page, false imprisonment. The next page is count 63, false imprisonment. Also includes count 64, false imprisonment. Next page is count 65, false imprisonment. It also includes count 66, false imprisonment. The next page is count 67, false imprisonment. And then it begins what I would call the common instructions, which are plea of not guilty, reasonable doubt, and burden of proof. That's standard 3.7. Let's talk about 3.8. I don't necessarily have a strong opinion on 3.88, which is on the next page. The first paragraph reads, the evidence which has been admitted to show other crimes, wrongs, or acts allegedly committed by the defendant will be considered by you only as evidence. That evidence relates to, do y'all want to go through that entire list, or you want to shorten that for the jury? I think we've been talking internally about opportunity, but I'm flexible. State, what do you want to read there?
I only want opportunity. That's all we cited in our notice. That's all I want.
Okay.
I agree with that, Your Honor.
All right, so we're going to take out motive, intent, preparation, plan, knowledge, or the absence of mistake or accident. So it will just read proof of opportunity, because that's kind of where we've been digging the entire trial. 3.9 is the standard weighing the evidence, which is on the same page. On 8, 9, and 10, just put he or she and take out the brackets. 9, has the witness been convicted of a felony or misdemeanor involving dishonesty or a false statement? Take out the bracket so I can just read it. 10, does the witness have a general reputation for dishonesty or truthfulness? So I can read it. The next part of that page I want to talk about is the paragraph that starts, it's 3 paragraphs down or 4. It says, you must consider the testimony of some witnesses with more caution than others. Typically, when I looked at that, that's typically read for the section dealing with accomplices and informants. Who is requesting that that paragraph be read, and kind of explain to me how that would fit into the general accomplices and informants section?
Judge, I don't believe it's applicable for the testimony we've had at trial. I don't believe that paragraph's applicable.
Mr. Davis, do you want it in there?
Judge, I would like it in there. I think the jury has seen from, especially the 12 individuals that testified, that they had their charges dropped in this case, and specifically, with Mr. Fears and Mr. Emanuel, I approached them with the null process of their cases.
Well, give it to me how you would want it to be read, because we've got to take what I have and make it applicable. So it says, you must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime. That is not applicable in this case, is it, counsel?
For example, a witness who had their criminal case vacated.
That is not part of the proposed brackets, is it?
I think you could almost argue that they were given immunity because their charges were dropped.
So you want, for example, a witness who has been promised immunity for prosecution. Is that what you want read?
Yes.
Okay. Is that more applicable, or is the next one hopes to gain more favorable treatment in his or her own case more applicable?
Judge, now that I'm sorry, not looking at the second, I was concentrating on the first part. I think hopes to gain a more favorable treatment in his or her own case would be more applicable in this situation. So we'd find taking out, because there has been no direct testimony of any immunity, just the charges being dropped. So maybe we left in just the hopes to gain a more favorable treatment in his or her own case. Because there was testimony about charges being dropped in this case. We'd ask for that to stay in that way.
So it would read as proposed, you must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, you should find the defendant guilty. Is that how you're wanting me to read it?
Yes, Your Honor.
State, go ahead and give me your response, please.
Judge, I do not dispute that there's been evidence that some cases were dismissed, not disputing that in any way. What I would say is that at the time of their testimony here in this court, as this instruction relates to, there is no pending case. And
Say that again.
at the time that these witnesses have testified in this trial, which I believe is what this paragraph contemplates, it specifically contemplates the testimony of witnesses, that there is no pending case against any of those witnesses. They have been dismissed. So I believe it clearly would be applicable if there was.
Would I read it if there was an alleged co-conspirator that had already taken a plea, and part of that plea would have been to testify truthfully and honestly in this case?
I believe so. Yes, sir.
But that case would be resolved. He had gotten potentially a lesser plea to testify truthfully in this case. So how is that the factor that the court should hang its hat on here?
Well, in this case is differentiated from that, and I agree with that example, 100%. But in this case, there's been no evidence of any agreement. There's been no evidence of any official statement that those witnesses gave prior to their case being dismissed, let alone in exchange for their case being dismissed. There has been no evidence of it. So that's a key difference.
Who asked to have this insert? Who put this in the jury instructions, the original ones? Did the state or Mr. Davis do it?
This was included by the state as just a part of the standard instruction. And that's why it was in there.
So you put it in there, but you're asking me to take it out?
Yes, Judge.
It's not part of the standard instructions I probably have read this maybe a handful of times in the last 5 years. So it's typically not something that I read.
I certainly didn't request that it be added in. Ms. Noah, could you pull up is that all right if I have Ms. Noah?
Sure.
3.9 from the Florida Supreme Court website?
All right, let's keep going while we look at that. Take out the italics, give only if defendant testified.
Yes, sir.
We need to take out defendant not testifying as far as the second paragraph there. Under 3.9A, the defendant exercised the fundamental right by not choosing to be a witness in this case. He was a witness, so that needs to be taken out.
Should we leave, is the court asking that we leave the first paragraph?
Mr. Davis, do you want the first paragraph left in there?
About the defendant testifying?
Under defendant not testifying, there's a first paragraph. It says the Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It's up to the state to prove the defendant's guilt by evidence. That paragraph's at issue. The next paragraph has been taken out.
Yes, I would like that first paragraph to remain.
We'll leave the first paragraph in and take the second paragraph out. What's the defendant's statement that's at issue under 3.9B?
I believe the only thing that that could apply to is a statement that has been introduced at trial that he said he gave on the day of his suspension regarding the property that was found in his car at a later date. That's all we have. I don't think we have any other statements that could apply possibly to that. I left that in there as an
Are you asking that that be red state, or are you indifferent to it?
indifferent.
Mr. Davis, look at that 3.9B and tell me what your thoughts are on it.
I don't think it would be applicable in this situation, Judge. It's not a statement that somebody's claiming the defendant made. It's a statement the defendant made himself to the jury.
Yeah, my lean right now, state, is to get 3.9B out.
Yes, sir.
Take out the brackets under 3.10, sub 2. You can leave, and just take out the bracket, leave the words, and have seen in the form of exhibits and evidence. Just take out the brackets, please.
Yes, sir.
On number 7 on the next page, I think that needs to be taken out. The give if applicable.
Yes, sir.
In the submitting the case to the jury under 3.13, take out the give if judge has allowed jurors to keep electronic devices during the trial. Just take out that, leave the paragraph, just take out the italics.
Yes, sir.
Take out the italics of give if applicable under during the trial. You may examine whatever exhibits you think they're going to be given the exhibits, so that is applicable. And then I'm going to go under the next section, take out the italics and leave A, take out B. I think we're going to have a way that they can review. Let me ask this. This is, and I haven't, I need to go back through them and look again. Is there anything, the way it's sealed right now, that the state or defense has concerns about going into the jury room?
So, Judge, the seized items for the listed victims would be items that, although they're in a manila envelope, how we have them in there, they are inside of them, the plastic baggies that have tape on them. They're still sealed by FDLE. They haven't been opened. But those do contain the items that they're charged to be, suspected paraphernalia, suspected methamphetamine. Likewise, the items from the defendant's patrol car. But they're all sealed. None of them are open.
Well, and that's the thing is, and I've done it both ways, depending on the nature of what we've got going, where I either bring them in here and let them look at the items. I've also felt comfortable enough at times that I don't let them unseal them without notifying the court first that they're going to unseal them, but letting them go to the jury room in a sealed environment. Mr. Davis, do you have any preference with that?
I think as long as they're sealed, it's fine.
Yeah,
Your Honor.
okay.
I agree.
So what I think I'm going to do is all exhibits will be sent into the jury room with you when you begin to deliberate. If you desire to unseal an otherwise sealed piece of evidence, please request the ability to do so in writing. Will that work?
Just want to make sure we have that correct.
Mr. Davis, you okay with that? That tells them, and we're not going to take scissors back there. If you want something unsealed, let us know, and we'll provide. We'll see what it is, and we'll provide a way to do it.
May I read that back to you? Just make
Sure,
sure
yeah.
everything is correct. All exhibits will be sent into the jury room with you when you begin to deliberate. If you desire to unseal an otherwise sealed piece of evidence, please provide it in writing.
Please provide that request in writing to the court before unsealing that piece of evidence. That just preserves the integrity of some of those paraphernalia items. So if they want to review those more closely, they can do those in a better environment.
Yes, sir. Judge, Mrs. Nowak has now from the Florida Supreme Court website 3.9 weighing the evidence up.
Hold on, okay.
Specifically the paragraph that we've discussed regarding hopes to gain more favorable treatment.
Mm-hmm.
We have that from our pulling this up just now from the Supreme Court website. We do have that included in the standard instructions. And just to be clear, that's the only reason I left it in there.
So, all right, let's go to 3.9 then, because that's basically where we're at anyway, correct?
That's where it is, yes, sir.
Where it's on the second page, it's give as applicable and if requested, law enforcement witnesses, expert witnesses, accomplices and informants, child witnesses, when a defendant testifies, et cetera. So basically what that is how the jury is supposed to look at how they're supposed to indeed weigh the evidence and how they're supposed to give additional credence or not give additional credence to certain types of sub-factors, such as a law enforcement witness, which we did have law enforcement in this case. Everybody would agree with that.
Yes, sir.
An expert in this case. I don't think child witnesses, do we have a child witness in this case? I don't remember a child witness. So child witness obviously is coming out. The defendant testified. Take out the italics there, madam, and the comment on 3.9.
Are the italics you're referring to the give only if defendant testified?
So give as applicable is under 5 is an italic?
Okay, it looks like that's already removed from the hard copy.
Hold on. Okay, well, I'm looking at the copy that I got printed out from under 3.9. You're right, counsel. You're right. I had printed out my own notes on 3.9, so I was literally looking at 3.9 again. So let me go backwards to 3.9. I was literally looking at the Supreme Court instruction. I had attached it to the end for my own reference, and that's what I was looking at as the next page. Okay. So we're back at 3.9. Obviously, there was nothing put in here about child witnesses, so don't worry about that, madam. That's just in the standard. So, but that kind of goes to my point is 3.9 in and of itself has many things already that weren't included in here. Like the child witnesses, you took it out.
Yes, sir.
So you left this one in. Anybody want to say anything else on the, I guess, let me look at something real quick here. How does, Mr. Davis, that paragraph that we all agree, and it's titled as accomplices and informants. That's how it's titled in the Supreme Court instructions. I mean, that is the title. I'm looking at 3.9 right now. In weighing the evidence, it already says, and it lets you argue it in closing. Number 4 says, did the witness have some interest in how the case should be decided? And you asked every witness pretty much, do you have a civil suit going on? And I think maybe all but one indicated that they do. And then subsection 6 says, has the witness been offered or received any money, preferred treatment, or other benefit to get the witness to testify, which is another potential argument depending on how you want to construe that. So I guess does 4 and 6 to some extent not cover what the section titled accomplices and informants normally covers?
Judge, and the way I was looking at it was, again, in the brackets where it says hopes to gain more favorable treatment in his or her own case, I think we saw that some people have already received more favorable treatment. And there was at least one witness when I was asking about the civil case, and I said, well, wouldn't a conviction here help your case? He said, yes. So it doesn't say specifically a criminal case. It could also be the civil case.
Sure.
Based on that logic,
I think it's a good argument. I mean, I think that's something in closing that you're free to use, and you set it up that way that you can use it. I guess my concern is what does, other than inserting an accomplices and informants section in a case that doesn't really deal with accomplices or informants, I don't know how 4 and 6 don't cover what we need covered, which is, do they have an interest in how this case should be decided? Well, yeah, their civil case, I think many of them indicated it would certainly help them in their civil case. And then 6, has the witness been offered preferred treatment or other benefit to get them to testify? I think that at least opens the door for you to argue, yeah, their cases got dismissed in conjunction with potentially what you heard today. I think that door is open when they review the credibility of the witness. So my thought right now is going to be to take out the accomplices and informants paragraph, and I will give defense liberality in arguing what I think he wants to argue in his close about the credibility of the witnesses that we've heard over the last week, or some of the witnesses we've heard over the last week. So I'm going to take that "you must consider" paragraph out, just because I don't think, I'm not going to insert something other than accomplices and informants in these jury instructions. I think it can be dealt with in the general weighing the evidence section. I am going to leave sections 6, 7, 8, 9, and 10 in, which are the give as applicable sections. Madam, do you have any questions for what the court's thoughts are right now? All right. Mr. Williams, anything that you want to say at this point in time?
No, Judge.
You satisfied with the proposed changes?
Yes, sir.
Mr. Davis, go ahead and put on the record what you want to put on the record with the proposed changes that the court's made, any and all.
Judge, I think I was clear on the one with the accomplices of that over my objection. So I just want to note I objected to that. You're removing it, so it's clear for the record. And I don't think there was anything else I objected to, and everything else looks
Okay.
good and proper.
Let's do this. It's 9:25. I'm going to give the state and defense about 10 minutes to get those printed, look over them together. Mr. Jason, if you'll get oh, that's a good point. Mr. Jason's waving at me. That's why he does a great job. Let's go ahead and take care of the verdict form while we're dealing with this. So if we need to make any changes, we can do it. All right, everybody got their verdict form out?
Yes, sir.
Same style on that one, madam, as be great with that case number. We, the jury, find as follows as to the counts charged and information. Count 1 is guilty of racketeering as charged or not guilty. Count 2 is guilty of official misconduct related to a Maria Turner as charged or not guilty. Count 3 is guilty of official misconduct related to Reginald Williams or not guilty. Count 4 is guilty of official misconduct related to Benjamin Bowling as charged or not guilty. 5 is the same language with Derek Benefield. 6 is the same language with Richard Drigger. 7 is the same language with Teresa Odom. 8 is the same language with Joshua Clenny. 9 is the same language as Joshua Emanuel. 10 is the same language with Stephen Van. 11 is the same language with Trevor Day. 12 is the same language with James Fears. 13 is the same language with Kimberly Hazelwood. And then it goes perjury, starting at 14. It says guilty of perjury related to Maria Turner's charge or not guilty. 15 is the same perjury with Reginald Williams. 16 is the same Ben Bowling. 17 is the same with Derek Benefield. 18 is the same as Richard Driggers. 19 is the same with Teresa Odom. 20 is the same. Joshua Clenny. 21 is the same with Joshua Emanuel. 22 is the same with Stephen Van. 23 is the same with Trevor Day. 24 is the same with James Fears. 25 is the same with Kimberly Hazelwood. The next one is 26. That's guilty of fabricating evidence. The first one is there is related to Maria Turner or not guilty. This 27 is the same with the fabricating evidence. Reginald Williams. 28 is Benjamin Bowling. 29 is Derek Benefield. 30 is Richard Driggers. 31 is Teresa Odom. 32 is Joshua Clenny. 33 is Joshua Emanuel. 34 is Stephen Van. 35 is Trevor Day. 36 is James Fears. 37 is Kimberly Hazelwood. 38 is guilty of possession of a controlled substance related to October 2nd, 2017 is charged. 39 is guilty of possession of controlled substance related to October 16th, 2017. 40 is February 9th, 2018. 41 is February 15th, 2018. 42 is March 14th, 2018. 43 is April 8th, 2018. 44 is April 17th, 2018. 45 is May 4th, 2018. 46 is June 3rd, 2018. 47 is June 7th, 2018. 48 is August 1st, 2018. 49 is August 1st, 2018. Are there two counts on the same date there?
There are.
State,
Judge.
okay.
One is for methamphetamine, one is for cannabis.
And August 1st was the search date of the vehicle. What was August 1st?
That was the search date of the vehicle.
That was the impounding of the vehicle, was it not?
It was impound. The evidence was, in our theories, that it was kept.
Because it was searched the first part of September, but it was impounded August 1st. Is that right?
The last day the defendant could have possessed it. Yes, sir.
Gotcha, okay. 50 is paraphernalia, possession of drug paraphernalia for August 30th, 2017. The next one is paraphernalia. 51 is paraphernalia, August 2nd, 2017. 52 is October 16th, 2017. 53 is February 9th, 2018. 54 is February 15th, 2018. 55 is March 14th, 2018. 56 is April 8th, 2018. 57 is April 17th, 2018. 58 is May 4th, 2018. 59 is June 7th, 2018. 60 is August 1, 2018. 60 is August 1st, 2018. And then 61 is guilty of false imprisonment related to Ben Bowling. 62 is false imprisonment with Derek Benefield. 63 is Richard Driggers. 64 is Teresa Odom. 65 is Stephen Van. 66 is James Fears. And 67 is Kimberly Hazelwood. Then it says, so we say we all this day of 2021 with the four-person signature section. Mr. Davis, understanding that you have properly preserved an objection as to all the counts, but specifically with respect to racketeering, count 1, and it was argued properly this morning. Is there anything that you want to say with respect to the verdict form?
Yes, sir.
Mr. Williams, anything from you in that regard?
No, Judge.
All right. So let's take 10 minutes, let the state and defense go over the final instructions. If you'll give the court 2 courtesy copies as well, I'll review it in my office, and then we'll come back out, make sure everybody's comfortable with the changes that we've made, and bring the jury in, okay?
Judge, just to be clear, it should be, Ms. Nowak will be making the edits, printing a copy for myself, Mr. Davis, and 2 for the...
Give 2 to Mr. Jason, he'll bring me 1.
Yes, sir.
Thank you. Be in recess.